We're with Professor Marci Hamilton, law professor at Cardozo Law School, and I want to ask you a few questions about RLUIPA. First of all, the Justice Department claims that there is no longer in the courts a question over the constitutionality of this act. And we know that its predecessor, you well know, RFRA, was indeed found unconstitutional as it applied to the states. Is the Justice Department correct that there is no constitutional problems right now?
Unfortunately, the Justice Department is exaggerating, actually. Several courts have addressed constitutionality, but the vast majority of the cases have dealt with the substantial burden or the equal terms provisions. So the courts really have not gotten to constitutionality in most areas. And so we'll see these challenges. So far, the Supreme Court has ruled on the establishment challenge against the prison side of RLUIPA. That means there's a lot left to be done.
Okay. And on today's panel, there was a lot of discussion about the great need for this act for religious groups seeking to build houses of worship, and that without this act, their zone or areas for building these houses of worship would be greatly limited. Is that the case? Is this act needed?
Well,
in that way?
It's my view that it's not needed. Religious applicants actually do well in the process. That's what the social scientists have told us in their neutral studies. The question is whether or not you can get the plot of land that you want, as opposed to being in another part of the jurisdiction. Now, any place that excludes religious assemblies or uses altogether clearly violates the First Amendment, but that is not what happens in the United States. Basically, what's happened is we've changed the political play at the local government level, so it doesn't matter what kind of master plan or goals a community has. If an ambitious religious use comes in, it gets a privilege to get in the middle of that and alter the outcome. And so not only do I think it's not needed, but I also think it's had some negative side effects that no one contemplated but need to be studied now. My view is that elected representatives are supposed to be representing the interests of all, and I would hope that a statute that was put into place essentially by stealth, with hardly any of the members even knowing it was being enacted on that date, maybe at this point, maybe members would like to reconsider and just figure out, has it been negative, has it been positive, and in what ways? And I think amendments are in order. Well, the Free Exercise Clause has tremendous teeth against discrimination. And any kind of intentional discrimination by government is actionable under the First Amendment. But we don't see a lot of intentional discrimination. You certainly don't see overt intentional discrimination. And so what they are hoping to do is to, they say that they're trying to find out if there's subtle discrimination. You hear the term subtle a lot. I haven't seen it. Now, maybe that's because local communities that are discriminating aren't calling me. But as a general matter, communities are dedicated to their plans, their future, their vision for what they're going to have, whether it's more open space or better places for their children to play or whatever. And RLUIPA undermines those local prerogatives. And so it's my view that it is a real violation of federalism. If there's anything that ought to be local and belong to the states, it ought to be land use. And I do think we will get to that federalism challenge eventually. But right now we're enmeshed in trying to interpret the statute.
Okay. And for our readers of the blog who want to find out more about RLUIPA, and you've written quite a bit about it, can you point them to an article or a website that they could go that you would suggest for them to look at?
Actually, I've just completely revamped my website at Cardozo Law School. So if they just go to my website, everything I've written is up there. Most recently, I published a piece in the Albany Government Law Journal arguing it's unconstitutional at length and violates really settled principles of constitutional law. But I've written, as you say, I've written a lot about it. It's all on my website.